Hello, my name is Travis. I am an attorney located in California. I've been practicing law for 10 years, and today I want to talk about your rights when interacting with law enforcement and the procedure law enforcement must follow when interacting with you. So by the end of the video, you should be able to answer the following questions. During a traffic stop, what questions do you have to answer? What questions can you refuse to answer? How long do you need to stay? When can the police search your home without a warrant? When can the police arrest you without a warrant? During a stop and frisk, what can or cannot the police do? How invasive can the search be? So all of these questions and more will be addressed in the course of this video. So let's get started. Your rights when you are being searched or arrested are governed by the US Constitution, specifically the Fourth Amendment. The Fourth Amendment protects you from unreasonable searches and seizures. So what are unreasonable searches and seizures? Well, any search conducted or arrest made without a warrant is per se or presumptively unreasonable. So what is a warrant? Well, it's a piece of paper issued by a court that gives the police officer permission to search your home or to make an arrest or to search your car. In order for a judge to sign a search warrant or arrest warrant, there must be probable cause. What does probable cause mean? To have probable cause to arrest someone is to have a reasonable basis to believe that someone has committed or is committing a crime. To have probable cause to search a home is to have a reasonable basis to believe that evidence of a crime can be found in that home to be searched. So, what happens if a police conducts a search or makes an arrest without a warrant when one is required? If that happens, then whatever evidence they collect, whatever contraband they seize during the unlawful search must be excluded during trial. I'll give you an example. Let's say you run an illegal cockfighting ring in your basement, and the police, they've been monitoring you for a while. They know where you live. They know where these cockfighting games occur. They have ample opportunity to go and obtain a warrant. But for some reason, they decided not to get a warrant, but instead, they barge into your home and forcibly enter your basement where they seize everything. So if later you are charged with felony cockfighting, what can you do? Well, you can challenge the evidence collected during the unlawful search, and then more likely than not, you will be able to exclude that evidence from trial. The police cannot search you or arrest you without a warrant, because if they do, then it becomes violative of your Fourth Amendment rights, and then everything they collect would be useless to them. Now, so far, everything is pretty straightforward, right? Constitutional law is never straightforward and rarely simple, because over the last 200 years of US jurisprudence, the Supreme Court has discovered a number of exceptions to the Fourth Amendment. That is to say, if the facts at hand fall under any of those exceptions, then law enforcement can search or arrest without a warrant. So what are those exceptions? Well, today I want to go over the most common exceptions to the Fourth Amendment. Let's begin with search incident to arrest. When a police officer makes an arrest, the police officer is exposed to certain elements of danger. During an arrest, the arrestee is liable to get emotional and might reach for a weapon to obstruct the arrest, or there might be hiding somewhere on the premises a Confederate and who is liable to jump out and injure the police officer. So this rule is really looking out for the safety of the arresting officer, and it allows the officer to conduct a limited search without a warrant in order to protect his safety. Let's say the arrest takes place at a home. During an arrest, the police officer is allowed to conduct a protective sweep, which is limited to a cursory visual inspection of places where another person might be hiding. So here, the police officer can look behind the curtain or behind furniture to confirm there is no Confederate of the arrestee hiding somewhere and ready to come to the arrestee's aid. The police officer cannot look for another person in the chest of drawers or under that very small carpet, because it is not reasonable to think a human being might be hiding in those places. Now, if an arrest takes place in a car, then the police officer can order the arrestee out of the car and do a quick search of the passenger area in the car, including the glove compartment. Because during the arrest, it is possible that the arrestee can race back to his car and reach for a weapon. In this case, the person is wearing quite a heavy coat. So the police, incident to an arrest, is also allowed to search the person's outer clothing to make sure there is no weapon hidden anywhere that could do the officer harm. Generally speaking, no arrest warrant is required unless the arrest occurs in a home. As long as the police have probable cause to believe that someone has committed or is committing a crime, then the police is free to arrest that person in public without a warrant. In this example here, the suspect commits misdemeanor or felony in the officer's presence by selling counterfeit goods. So the officer has the authority to arrest him without a warrant. So next, let's briefly talk about Terry stops, otherwise known as stop and frisk. Now this is a particularly contentious aspect of the law and is a very brief detention of a person usually in a public space. Also, the frisk component or the pat-down is limited to searching for weapons on the suspect's person for the purpose of protecting the officer's safety. To stop someone, the officer needs to have a reasonably articulable suspicion that the person has committed or is committing or is about to commit a crime. A reasonable suspicion is an evidentiary standard that is much less than probable cause, but more than a mere hunch. To frisk the suspect. The police officer needs to have a reasonably articulable suspicion that the person is armed or dangerous to the police officer. And the frisk has to be specifically targeting weapons. So the pat down needs to be restricted to the suspect's outer clothing. And while doing the pat down, the police officer is looking for things that are immediately recognizable as a weapon. So if it is too small to be a weapon or too soft to be a weapon, then the police officer must abandon immediately. The police officer is not allowed to manipulate the object through the suspect's clothing in an exploratory manner in order to determine whether it's a weapon or not. Okay, so in this example here, the police officer has stopped Mario to frisk him, and then during the course of the pat down, the police officer discovered something soft. Now, normally the police officer needs to abandon the soft object and move on, because if something is soft and squishy, it's probably not a weapon. However, in this case, the officer actually reached into Mario's pocket and extracted the item, which turned out to be a mushroom. So in this case, the officer has exceeded his authority under stop and frisk. And therefore, the prosecutor will never be able to use the mushroom against Mario because it was obtained illegally. All right, so let's move on to the next exception to the Fourth Amendment, and that is exigent circumstances. There will be a time when time is of the essence, and going to a court to obtain a warrant would be impracticable, because such a delay would lead to the destruction of evidence, or the escape of the suspect, or even injury or imminent injury to third parties or to the police officer himself. So under these circumstances, the officer is allowed to search a home or business without warrant. One example of exigent circumstance is when the officer is in hot pursuit of the suspect from the scene of the crime. And during this hot pursuit, if the subject runs into a home, the police is allowed and authorized to follow the subject into the home.